We all want to feel secure in our homes, and if the reckless or abusive acts of government officials violate that security, we expect to be able to hold them accountable. IJ recently launched 2 cases in Georgia to uphold that principle. One in which a town bulldozed a house without warning or compensation, and another where FBI agents violently raided the wrong home. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely and IJ attorneys Dylan Moore and Patrick Jaicomo. This is Beyond the Brief. So, Dylan, tell us about Eric and the home he was repairing in Georgia.
So Eric is by trade a master carpenter. That's all the way back since high school how he's made his money. So generally what he'll do is he'll either buy a house himself or he'll work for a real estate investor to come in, buy a home that is a little bit dilapidated, has seen better days, put a bunch of love and care and skill into it, and then sell it so that somebody else can live there. And so Eric's been doing this in New Jersey, where he's from, and recently he started doing it in Georgia because that's where his mom's family is from, and he wanted to kind of return to his roots. So he bought a house in Covington, Georgia, and renovated that. He lives there with his wife now, and it's beautiful. I've been there. But the story that we're going to talk about today centers around a house that he bought in the county of Macon, Georgia. So in 2022, Eric bought this home kind of tucked back at the end of a cul-de-sac in a neighborhood in Macon. And he started doing all of the things that he does when he makes a home beautiful. He was buying materials, fixing things up, taking care of the landscaping, stuff like that. Fast forward to September of 2023, and he gets a call from one of his neighbors. And the neighbor tells him, Eric, there's a dumpster parked out front of the home that you've been working on. And naturally, Eric was really confused. He didn't ask for a dumpster to be placed there for like taking things off the property or anything like that. He had no idea why this dumpster was there. So he has his neighbor go over and give the phone to one of the people on the crew that was installing the dumpster. Eric's like, hey man, what are you doing at my property? Why are you putting a dumpster here?
The owner of the demolition company, he said, sir, I don't know what's going on with this property, but I was told to knock this house down. I said, look, sir, please don't touch my house. I'm gonna go get to the bottom of this and go see whatever.
Eric had no idea what he was talking about. And when he was talking to the demo crew on site, they agreed with him that it didn't really make sense that this house that was actively being repaired was somehow scheduled for demolition. So Eric, at that time, convinces these guys to take the dumpster off of the property, and then begins this incredibly frustrating search for why the dumpster was there to begin with. So Eric goes from county office to county office in Macon, trying to ask anybody who might have anything to do with this why his house was marked to be demoed. And he doesn't really get anywhere. He talks to some of the code enforcement authorities, and they were the people who were in charge of ordering the hit on the house, Eric later found out. But all they would tell him were things like, well, the house is scheduled for demolition, and if all the repairs aren't done really soon, it's going to be torn down. He couldn't get any more information from them, like what repairs were supposed to be done.
And he never got notice of this, like when he bought the house, that, hey, the city's mad about this house, or like as he was working on it, nobody ever sent him letters being like, hey, we don't like this house or whatever.
Nothing at all for Eric. He bought the house, like I said, in 2022. Title was totally clear. There were no liens. There were no public records suggesting that it was on any sort of demolition list. There was a letter, we think, sent to somebody who owned the property 2 owners ago.
Helpful.
Yeah, right? So that didn't give him a lot to go on, mainly because he didn't know about it.
Sure.
And there was no way for him to know about it.
Right.
And so the code enforcement officers basically tell him, I don't know, fix it up or it's going to be torn down.
And there's not like some sort of posted notice? Like you'd think that would be the way, among others, that you would
like
ensure
a thing
that
taped to the door.
to the door. Yeah.
Right.
The county claims that there was one, but Eric never saw it. And he was there constantly, personally fixing up the house. So the county claims that there was a posted notice, but for the time that Eric owned and worked on the property, he never saw a notice. So next he goes to the assistant county attorney's office, and he asked the assistant county attorney, could you please write a letter to code enforcement telling them, like, I'm working on this house actively, it shouldn't be torn down. And the county attorney tells him, no, I'm not going to do anything to stop the code enforcement process. So for the next 2 months, he's trying harder than ever to get the house in good shape, not really sure what he's supposed to do to ward off the demo. But in mid-November of 2023, so less than 2 months after the dumpster was parked out front of his property, he gets another call from a neighbor that says they're tearing your house down. So Eric jumps in his car and drives over to the property.
When I pull up and saw the house demolished, I was devastated. My heart started racing. I was tearing up. I started sweating. I had to really calm my body down because I was about to faint. I couldn't believe they did that.
It was just too late. Half the house was gone. He was storing the materials for the renovation inside of the house, and those were all destroyed as well. And Eric still can't get to the bottom of exactly why they singled this specific house out for demolition. He did come to find that it was torn down based on this power that Macon claims to have called a nuisance per se abatement power. It's something that Macon's mayor has been using through the code enforcement department to basically tear down homes without involving courts at all.
So wait, not only was there not a notice posted on his home, there was never a court hearing in which the property was condemned by a judge or a magistrate. This was purely the mayor saying, you lose, your house is a nuisance, and we're going to take it from you.
That's exactly right. Eric never had a day in court. He never had an opportunity to present evidence to anyone that he was working on the house, even though the county officials certainly knew that he was working on the house. But there was never any sort of formal process before this house was torn down.
So has this happened to other people? Does the city have like a vendetta against Eric, or is this going on with a bunch of other houses?
Unfortunately, it's not a one-off issue. Macon has been tearing down houses at an extremely fast clip since they launched what they called the Blight fight in 2021. They're up to over 800 houses torn down through this same no court involved process. And they're extremely proud of it. At one of the big milestones, I think it was maybe the 700th house or maybe one of the 100 markers, the county council presented the mayor with a trophy, essentially. It was a brick from that milestone demolition with a little plaque put on it, celebrating how many demolitions the county has done.
I just don't get it. I mean, why? If you're presumably if you're tearing down that many houses, it's because you want there to be, nicer, newer houses. And so, what would motivate them to then tear down a house that was being renovated into a nice new house?
We have no idea. I mean, we've been trying to get to the bottom of why they're tearing down this many houses in general. And to be candid, Macon does have a bit of a blight problem, like a lot of American cities. There are houses that are dilapidated and in need of love. But there doesn't seem to be too much rhyme or reason to the houses that Macon specifically is marking for demolition. Some of them are closer to city centers, but Eric's wasn't. It was tucked away in a quiet little cul-de-sac.
Did they ever tell Eric what exactly was wrong with his property, what needed to be fixed in order to stop or forestall this demolition?
They didn't, despite him asking many people over months.
Wow. And they've given no justification to date today, even after the lawsuit has been filed.
Their line has basically just been the house was a nuisance per se under our county code, and therefore we have done everything that we need to do in terms of checking the boxes before tearing it down, because the mayor's just allowed to, by executive fiat, decide that something is a nuisance.
Does the county code at all define what a nuisance is? Does it give the mayor, or does it limit the mayor's discretion in any way?
On the county's reading of the code, I think the answer is no. They like a lot of local governments, there are factors when you determine whether something is a nuisance. But there's also a weird provision in the code that basically just says, if there is a nuisance per se, the mayor can say that that is so, and then basically all the downstream consequences are a foregone conclusion at that point. Like, the house is just marked.
So a lot of our cases that have involved, sort of this blight idea and things like that are cities sort of blighting a whole neighborhood because they want to give all of that land to a developer and, put up a whole new neighborhood or something like this. And this seems too sort of like surgical almost to really have that purpose. So how does this relate to sort of these other kind of blight situations that we have going on?
Yeah, they're actually pretty different, I think. Macon has also been very interested in development recently, so there might be a bit of a tie-in there when they're trying to demolish homes that are closer to areas that they want to develop. But for homes like Eric's, it's kind of mind-boggling. Like, I'm not sure why they would go all the way back to the back of this neighborhood, mark a single house, when there are other houses in the same neighborhood that are in worse shape, that are not actively being repaired, and pick that one out.
Yeah.
Now, it's very different than what we see in some of our other blight cases. So, like, our case about eminent domain in Ocean Springs, Mississippi, is a situation where the town blighted a historic black neighborhood that is right next to sort of the developing business and restaurant district in the town. And there, I think the plan was kind of clear. Like, the blight designation that they put on this area would allow the town eventually to take that property by eminent domain and hopefully give it over to a developer who would use the property in a way that the town likes a little bit better than single family homes. But in a case like Eric's, it's much more confusing. Like, we have been trying to figure out exactly why the town or the county is singling out certain homes for demolition, but it's been hard to get to the bottom of.
So, Keith, this sounds also to me sort of like the
Memphis Environmental Court case?
Yeah. I saw you smiling, and I'm like, are you reading my mind?
Right. No, I was smiling because, that's very similar to a case that we're litigating and have been litigating now for several years. In Memphis, there's a court called the Memphis Environmental Court, and the way that this court functions, similar to the way that this process plays out in Macon, is property owners can lose their homes. At least in Memphis, they call them judicial proceedings. I don't know if they accurately resemble what a judicial proceeding is supposed to look like, but at least they put in the effort to try and justify what they're doing under our current understanding of due process. But what's so odd about what's going on in Macon here is just how broad and narrow it is all at once. 800 properties scattered across the county. And there's no rhyme or reason connecting these. There's no judicial process, even in name, for challenging these sorts of things. I mean, what is a property owner supposed to do? I mean, in Eric's case, he found out about the demolition by chance, as I understand it, just because they started putting a trash receptacle on his lawn.
A dumpster,
Keith. A dumpster is the word I was looking for. You could see the hamster wheel turning. And that's remarkable that's the first sign that he gets. And in fact, I think one of my favorite things about reading the complaint, is that the company responsible for bringing the dumpster said, quote, "This property is too clean to be demolished." Yep. Isn't that right?
Yep. And they kind of had that same, it was the same company that ended up doing the demolition itself. And when Eric arrived on the scene that morning, they kind of had the same thought process. The dumpster folks were very surprised. The dumpster folks.
The dumpster people.
Yeah, they were very surprised that this house was being marked for demolition. And they still did it, which isn't great of them. But they were surprised the entire time.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost-efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
So, shifting gears here a little bit, we'll come back to Eric's case. Patrick, you're also dealing with a case that's very strange and kind of random thing happened to a house in Georgia. So tell us what's going on in your case.
Yeah, so this case, which is called Martin versus United States, has a lot of similarities to the case we just discussed, but is fundamentally different in a lot of ways. And so, as you mentioned, the similarities are, if you have a house in Georgia, you better just hope you don't end up on the unlucky side of some government misbehavior. This case involves misbehavior by the federal government and of a very different sort, because this case is about a wrong house raid that took place in Atlanta. And so there is some interesting overlap and analogies that can be drawn from these two cases, but of course the legal aspects of them are quite different. And so this is a case where an FBI SWAT team was seeking to raid a suspected drug dealer's house. And in a neighborhood that's fairly upper middle class, nice big houses, yards are nice, well-manicured lawns, garages, all that stuff. And for reasons that we'll get into here shortly, The SWAT team was supposed to raid and, in fact, had a warrant for a house on Landau Lane. But instead, it raided our client's home on Denville Trace.
Similar, easy mistake.
Exactly. And there are a lot of other kind of smaller aspects of the houses that should have tipped off any reasonable person that they were not going to be raiding the right house. You'd think, among other things, you would check, the house numbers, which were also different. But here, ultimately, it resolved to the FBI agent claiming that he used his personal GPS device and it took him to the wrong house. Now, the houses are down the block from each other. He claims to have driven by the target house, but nevertheless, just kind of blindly in a Michael Scott-esque fashion, follows his GPS into the pond. Except for instead of driving his Chrysler Sebring into a pond, he's leading a 6-person SWAT team into an innocent family's home in the middle of the night. And so here they lined up at the door, they kicked in the door, they detonated a flashbang. It startled awake our clients, Trina and Toy. Trina's 7-year-old son was asleep in his bed. She couldn't get to him. Her and Toy hid in the walk-in closet of the bathroom off of the master bedroom as the SWAT team came in, guns pointed, shouting, pointed guns at the 7-year-old while he was hiding under his sheets in his bed. Dragged our client Toy out onto the floor, began, of course, shouting questions at him. At some point, he mentioned his address, which, of course, was not at Landau Lane. And he says at that point, all the noise just stopped. And apparently one of the FBI agents then grabbed a piece of mail, looked and saw, oops, we're at the wrong house. And then they pretty much just hutted out of the house, went down the street, ran another raid, and then came back, and the leader of the SWAT team gave a business card to the family and left as their minds were just spinning about what had happened. And what this case is about is, even though everyone agrees that was a terrible mistake, whether the federal government can get out of paying for the mistake and then leave the cost of that mistake on the shoulders of our clients, who, of course, were horrifyingly traumatized. We're dealing with a whole family whose sort of sense of safety was shattered in a moment in ways that none of us, unless we've been the subject of a wrong house raid, could even imagine. I mean, the terror of an exploding grenade in your house in the middle of the night and a team of men in tactical gear with assault rifles pointing flashlights in your face and screaming is just something that I don't think any of us can fully appreciate, even though we've seen that sort of thing in movies. And so the question really is, can the government wiggle its way out of standing behind the actions of its SWAT team here? And so far, the answer has been yes, and we're asking the Supreme Court to step in and say no.
The thing that stands out to me about both of these cases is that there's kind of, there's no way to avoid this situation, right? Like if the government randomly decides to demo your house, doesn't tell you about it, doesn't give you any process for stopping it, right? Like you have no control over that happening, and you have no control over whether, an FBI agent is good at using GPS or not and burst through your house. To me, one of the things that's most amazing about this story is that Toy even had the wherewithal to just shout his own address, I guess, in the middle of this. Like that would never, if somebody's, entering my house, it would never occur to me to, like they did this wrong, right? And so it's completely astounding that there's no kind of
I think these answers
this.
these are answers to questions that were being shouted at Toy. So I don't know that we can take credit for saying the right address, other than being at the right address, which the FBI was not doing at the time.
Yeah.
Well, they thought
still, it's incredible.
They thought their home was being robbed.
Right, of course, which I think most people would think. If the door gets kicked in and they're shouting, it's the middle of the night. Like the first thing you imagine is not, oh, the police are here, especially because, as you pointed out, you're completely innocent.
Right.
So this is not a situation where, for instance, you could imagine like, oh, well, my friends are drug dealers, or you could imagine a situation like the nuisance example where it's like, okay, well, they told me there were all these rules that I had to follow, and I didn't really follow them to the letter, but that shouldn't be good enough. Where it's like, no, both situations, nobody did anything wrong, and to your point, what's so frustrating and unjust about the situations right now is that, from the perspective of our clients, there's nothing that they could have done to avoid these situations. And so in one case, we took a bunch of precautions to ensure that something like the demolition wouldn't happen. That didn't matter. In this case, you're just innocent inside your house. Like there's no that's what's so horrifying about it is you'd never expect that to come through the front door of your house, and then one day it does. And, one of the things that really stands out in my mind as far as sort of crystallizing the impact that this can have is Gabe, the 7-year-old at the time, drew contemporaneously a picture of what happened. And so we have this sort of child's drawing of the house with the FBI agents who have like red and blue lights on them, and him kind of with all sorts of misspellings yelling "mom" and her saying back, "It's going to be okay." And so thank God in this case it was. And there's a situation here where Toy had a gun in the closet and he didn't grab it. But if he had, it's all but certain he would have been killed, if not both he and Trina. And God knows what would have happened to Gabe. And thankfully that didn't happen. But I think all of that underscores why it's so important that these mistakes just can't be made. And when they are, they need to be accounted for, because just some small bit of chance is what caused this mistake, but didn't actually have it lead to fatal consequences.
Yeah, and I think that's something that we've been thinking about a lot more here at IJ, is sort of this question of when people are harmed, even though that they've done nothing wrong, who has to bear the burden for those injuries? Should it be the innocent victims, or should it be the government that did the thing?
Right.
And I think to ask the question answers it, but
well, yeah, you'd think that, but the government's position, which often prevails, is actually no, it is the innocent victim who should pay for it. And the thing that's always left out of these discussions is anytime there's some big mistake like this, there's a cost that exists in society. It's just that it falls on the innocent victims rather than the government that actually perpetrated the mistake. And you could think of a situation exactly like this demolition, but it's a demolition company hired by a private party to tear down a house they own. The demolition company takes its GPS, just like the officer in our case. It goes to the wrong house and they say, okay, well, knock it down. The house still looks good, right? It looks like a nice house. We're just going to knock it down. Well, if that happens, it doesn't really matter that your GPS took you to the wrong place or you had some reason to think you were supposed to knock down the house. You have to pay for it in the private sector. And so it's the same sort of responsibility. The government should be more responsible than private actors in this way.
And I'm a little skeptical. I don't know if y'all are, but the idea that the GPS took them to the wrong house in the first place, I mean, sure, 15 years ago when GPS devices were separate and you purchased them and put them in your car, okay, maybe you could see this argument. But as someone who uses a GPS every day, I mean, I can't think of the last time I was taken to the wrong home. I mean, is this a case of user error or is this legitimately a GPS problem?
Well, I'll let you decide for yourself whether this makes you more or less suspicious. But once this case was filed, the plaintiffs asked for the GPS so they could inspect it and try to recreate these results. And they were told by the FBI agent that he had actually thrown it away.
Oh, that is convenient.
Yeah. So exactly. The dog ate my homework, and you're like, okay, where's the dog? And they're like, oh, well, I gave it away. It doesn't really add up. And it's, to your point, it's not really believable.
Right.
And even if it were true, again, it shouldn't matter.
Okay, so your GPS takes you to wherever.
Right.
I'm, going to a friend's house and I've never been to their house before.
Right.
They give me their address. I type in the thing. I'm not just going to go walking into this house that I can't confirm is the house, right?
Yeah.
Like I'm going to check some things maybe. I'm going to, check the numbers on the house.
I don't know what
If I can't see them, I'll probably text you and be like, hey, I think I'm at the right house.
Right. I don't know what to make of the state of the law as it exists right now, because everyone's expectations for food delivery drivers are higher than the standards that the government holds itself to when it's about to execute a violent raid of a home.
Point.
And that's crazy. I mean, you would think that some somewhat disinterested DoorDash driver who's dropping off Chinese food would not be more fastidious about checking the house number than a team of armed government officials who are about to throw grenades into a home and run in with the expectation that there might be someone dangerous in there. Right. I mean, it really is startling to see that this sort of mistake can be made at all, let alone made at scale. I mean, this is one of 3 currently being litigated cases that IJ has involving situations where police raided the wrong house. And it really is something that people need to start thinking about, because I think most regular people would expect oh, that just can't happen, or if it does, it's something that happens like once every few years. But as it turns out, it's something that's happening fairly regularly in the United States. And what's maybe even more concerning and probably more surprising to most Americans is that when it happens, the courts have uniformly kind of turned their back on providing any sort of remedy to the innocent victims.
Well, and I think, it's really frustrating. I agree that it's crazy that a DoorDash driver is expected to do a better job than an FBI SWAT team. But the truth is, only one of those two people faces consequences when they get it wrong. And that just can't be the case. If we want people to do a better job, we have to incentivize them to do a better job. And things like the FTCA are here to make sure that people are incentivized to do the right things. And when mistakes happen, the victims need to be paid.
Right. You're going to probably get a refund from DoorDash.
Right.
But you're not getting anything, at least if this case prevails, from the federal government, even though, and this is sort of a more inside baseball discussion of the purposes of the statute, this particular statute, as an amicus from 7 bipartisan members from both houses of Congress filed in our case, says this is a statute that was passed specifically to allow for claims because of wrong house raids that took place in the 1970s.
So yeah, let's get into the mechanics of the case here, because this case does involve the FTCA. Patrick, you and I have had a few experiences litigating under the FTCA.
It's the gift that keeps on giving.
It is. It is one of my least favorite statutes. But the one good thing it's supposed to do is waive the federal government's sovereign immunity. But it sounds like the 11th Circuit here decided that it was going to ignore that very clear statement and, in essence, create its own form of sovereign immunity against FTCA suits. Can you talk a little bit about what's going on here legally?
Yeah, so as I said, the FTCA was amended specifically to allow for claims arising out of wrong house raids. But more broadly than that, what it does is it allows some class of claims to be brought against the federal government itself, not individual federal employees. And part of the deal with the way the statute works is it's supposed to be sort of trading the liability of individuals for the liability of the government. Now, that's actually not the case when it comes to wrong house raids. Strangely enough, you're supposed to be able to sue the individual officers under Bivens causes of action, and Congress knew that when it was amending the FTCA, but that's sort of neither here nor there at this point. What we know is that the United States is supposed to take responsibility for this action under the statute. And the way that it operates is wherever this action took place, and it wouldn't necessarily be a wrong house raid. It could be a postal van crashing into your car or any number of other things that a federal employee might accidentally do or intentionally do to harm you. You're supposed to look at the law of the place and see whether that would be a tort action. So something like assault or battery or negligence. Here, that's obviously the case. You've got a federal statute saying, hey, if this was either assault or battery or trespass or negligence or anything like that under Georgia law, you can sue the United States directly for it. And the 11th Circuit ultimately threw this case out in large part because it said that this federal statute passed by Congress was actually inconsistent with the Supremacy Clause, which says that federal law is the supreme law of the land. And the theory behind that is, well, we're importing some sort of state cause of action. And even though Congress, federal Congress, is telling us
passed a federal law
saying we waive our immunity, you can sue us for these things.
Yeah.
The 11th Circuit says, no, thanks, actually, you can't do that. And so not only is that completely bananas in the context of telling Congress what it can do on behalf of the federal government, but also because the justification the Supreme Court has used to winnow away the Bivens cause of action wherein you can sue individual federal officers is based on the court's complaint that Congress hasn't provided for a cause of action. Well, here it specifically did that.
Right.
They said, hey, we saw a bunch of wrong house raids taking place. We didn't like that at all. You can sue these guys. And the 11th Circuit actually says, no, we think for reasons of sound policy that we don't want you to be able to sue federal officers when they're acting within the scope of their authority, which is, of course, the thing that triggers the FTCA's liability in the first place.
Well, and I've never seen either the Supremacy Clause used. I mean, it doesn't invalidate the FTCA, but typically you think of the Supremacy Clause as federal law overrides state law.
Yes.
We're going to strike down state law. Has the Supremacy Clause ever been used in any other context to restrict a federal law?
No, and every other context where it's come up, it has been completely dismissed out of hand as a silly argument to make.
It is silly.
It is silly. And so, nevertheless, it has prevailed in the 11th Circuit in this way since 2009. And of course, the federal government has been more than happy to avail itself of that on several occasions when it can't get out. So this is how it normally works. They will keep this card in their back pocket until it looks like there's no other way for them to win. And then they'll bring it out and they'll win. And then they'll do it again and they'll win. And now we're asking the Supreme Court to grant review. And the federal government's position is like, well, we're not really going to defend that. But the outcome is fine because there's some other exception that should apply that wasn't litigated by us, that wasn't raised. And so you shouldn't take this case and you shouldn't allow this innocent family to be able to get the remedy that Congress explicitly provided for them. And again, we're supported in our cert petition by an amicus brief from 7 members of Congress from both parties and both houses saying, no, this is exactly the thing that we passed this for.
We meant what we said.
Only for the U.S. Solicitor General to file something saying, well, actually, Congress doesn't know what its statute's supposed to accomplish. We, the Solicitor General's office, can tell you, court. And so I'm happy to take that issue to the Supreme Court and stand on the side of Congress and say, hey, the Institute for Justice and Congress are telling you that this statute's supposed to protect this sort of thing. The Solicitor General is here telling you, no, it's the children who are wrong. And that's kind of the situation that we're in right now.
So going back to Eric's case, because this case is, up at the Supreme Court. We're waiting for them to take it up. Eric's case is, very new, very early stages. So what are we sort of asking the court to do? Like, what's the legal claims here?
Our claims in Eric's case actually extend beyond Eric himself. So we're asking the court to completely invalidate this system of mayoral nuisance abatement per se that I was talking about before. The whole system where you can have your home destroyed without ever being hailed into court, without ever being able to defend yourself, and with no real right of review from a court, we're taking aim at the whole system. Because it just can't be the case that somebody can come and take your property, destroy your property rights, and never even give you a chance to defend yourself.
Does Eric have any chance for getting paid for his house that was destroyed, or how does that work?
That's part of it as well. Sort of the big ticket item is getting rid of this nuisance per se abatement process. But also for Eric, he suffered very real harms from the home being destroyed. And like I mentioned before, all the materials that he was buying to finish the restoration project were stored in the home. So yes, we're seeking for Eric to be compensated for all of the money that he's out from buying the place and from not being able to fix it up anymore, obviously because it's gone and because his materials are gone.
So is that damages or is that takings? Are we saying, hey, the government was trying to do a public purpose here and you just have to pay him just compensation? Or is it somehow different and it damages universe?
So this isn't a takings case. Ultimately, it's about sort of notice and process. So we're asking for the money that he's out in the materials and in the value of the house as damages because he never had sort of the procedural chance to defend himself in this whole process.
And so the damages suit itself, I believe, is proceeding under Section 1983. Is that right?
Yes.
But one of the unique aspects of this case, and maybe this is only inside baseball to the lawyers who really live and love this stuff, is that this is a Section 1983 claim, a federal statute being brought in a state court proceeding. Could you talk a little bit about, is there anything unique or different about that makes this case challenging or, more fun to work on?
Well, originally that was how we set it up, but the county didn't want to play that ball game. They removed us to federal court. So we're fighting about it in the Middle District of Georgia now.
Interesting. So we have this federal claim under Section 1983, but you also have, I think, these state constitutional claims.
True.
So now you get the other side of that coin.
Yep.
You're going to be litigating state constitutional claims in federal courts that can try to interpret what state law is, but obviously only the Georgia Supreme Court can really speak authoritatively on that. How has that process played out so far?
So far, we haven't had to go before the court and make our arguments yet. This case is still very early on in its life cycle. So we filed our complaint. The county answered when it removed to federal court. So now we're going to move into the discovery process where we're going to exchange a bunch of information with one another and try to really crystallize all the facts so that we can then go to the court and try to get a ruling on the law. But to circle back to the point about the state claims, because there are a few of them in there. We have a sort of a notice and opportunity to be heard analog to our federal claim. But there's one that I do want to highlight, which is a Georgia constitutional separation of powers claim. Because as I've mentioned, the power to determine a nuisance is kind of inherently a court's thing. In very specific circumstances, the executive, so like a mayor or a governor or something, can declare a nuisance per se if there's like an impending, obvious, and immediate danger to health and public safety. So if there's a raging fire, if there are disease-laden goods, things that are about to really, really harm a lot of people, then the executive, of course, has a little bit more leeway to act fast. But normally, declaring a nuisance, especially declaring a nuisance of a house, that's just sitting there, it's not, leaning on other structures, that is the realm of the courts. And so Macon can't just come in and say, we're going to do by executive fiat the thing that courts have been doing since before America was even born. And the Georgia Constitution has a provision that protects against that. So that's my favorite of our state claims.
Ooh, it's very interesting. Well, and another kind of odd similarity between these two cases that we haven't really discussed yet, correct me if I'm wrong, the code inspectors in Macon are armed. I mean, they look more like police officers, not code inspectors. I don't think I've ever seen an armed code inspector in my life. What's that about? I mean, what's going on with that whole situation?
It's a little bit strange because Macon used to be the town of Macon situated within Bibb County, Georgia. The two have consolidated. As part of that consolidation process, the sheriff's office kind of absorbed the Macon Police Department. And so the mayor now doesn't have as much direct control over the sheriffs as he used to have over his police officers. The code enforcement officers are they were developed in 2021, the code enforcement branch, as part of this Blight Fight initiative.
So they're basically just like the mayor's police.
I was going to say mayor's minions, but...
I like mayor's minions, the alliteration there. Yeah.
Well, and a lot of them are cross-deputized as sheriffs, so those are the ones that can carry weapons. So it's just a mess of like overlapping, crisscrossing authority and not really being sure who your boss is in some cases. It's a strange setup.
It's a classic situation where they'll have twice the authority and they'll claim half the accountability. Like this is every single time this happens. It's like, yeah, I can do 2 times as much and you just can't do anything about it, even though you could do something about it if I was one or the other. Classic.
So, Patrick, Dylan kind of told us, what's next for Eric's case. Can you tell us a bit what's next for the Martins case?
Yeah, so right now we're working on a reply to the Solicitor General's brief in opposition to certiorari, which is the fancy word for the Supreme Court taking the case. And then we'll find out in mid-January or so whether the Supreme Court is in fact going to take the case or whether it's going to deny this remedy that Congress provided to this innocent family who were the victims of an FBI wronghouse raid.
And if this gets denied, we have other cases kind of in this pattern, right?
Yeah, we as I mentioned, we have several other wronghouse raid cases. They all sort of have sprouted up around different legal theories and doctrines. And so we actually have another wronghouse raid case with the U.S. Supreme Court that will be filing a reply brief in that will be something for the end of January. And then we've got other things in the pipeline for our project on immunity and accountability to continue chipping away at the problems that have been created because of apparently the complete lackadaisical enforcement of any sort of requirements as far as identifying the proper house before actually raiding it with armed police.
Yeah, we certainly aren't done with the FTCA, and we certainly aren't done with wronghouse raids.
Thanks for watching today's episode. Our last episode involved IJ client Jennifer Heath Box, who was wrongly arrested and held by Broward County, Florida officers pursuant to a warrant for a different Jennifer with a different last name and a different age. It's an outrageous case, and it generated a lot of great questions, so let's take a look at a few. At Big Fist JP writes, Broward County said they investigated themselves and found they did everything perfectly. You can't make this stuff up. You really can't make it up. But there is a silver lining in the government's decision to double down and defend their officers' conduct. It can help show that the officers were acting pursuant to an official policy, which under the Supreme Court's decision in Monell makes it easier to show that the municipality should be held liable for their actions. At Greg Bering 1656 writes, was she booked before she saw a magistrate? Thank you for your content. Well, and thank you for watching, Greg, and thanks for the great question. Jennifer was booked at the Broward County Jail on Christmas Eve 2022, and they brought her before a magistrate judge on Christmas Day. But because the outstanding warrant was issued in Texas, it was considered an extraditable warrant, which led the magistrate to automatically deny bail without allowing her to raise mistaken identity as a defense. She was transferred to the Women's Detention Center later that day, where she stayed until December 27th. Unfortunately for Jennifer, this meant that she not only missed Christmas with her family, but she also missed her last opportunity to see her son Joshua before he left the country for a 3-year deployment with the United States Marines. At Dory Futo Rabbit writes, "I'm not an American, but that sounds like cruel and unusual punishment to me." That sounds cruel and unusual to me too. It's hard to imagine a legitimate justification for detaining arrestees with only a thin blanket in conditions so cold that the supervising guards were wearing jackets and gloves, much less a justification for subjecting those detainees to loud death metal music designed to disrupt their sleep. From a legal standpoint, however, Jennifer's treatment in the Broward County Jail does not implicate the Eighth Amendment's prohibition against cruel and unusual punishment. Why? Because that provision applies only to individuals who have been convicted of and punished for a crime. Jennifer, by contrast, was being temporarily detained. Her experience was still blatantly unconstitutional under both the 4th and 14th Amendments, but it technically did not implicate the Cruel and Unusual Punishments Clause. At BJ Bergner 8873 writes, "Is the judge that denied bail just as at fault? Is the judge not in place to make sure the legal system plays by the rules? Could the judge not say, the state has not met the burden of proof that they have the correct person, and then release her?" Great question, BJ. Absolute judicial immunity protects judges from lawsuits over the decisions they make on the bench, so we could not bring a claim against the judge in this case. But it's worth noting that a system designed to process people into jail without any mechanism for confirming their identity creates a significant risk of imprisoning the wrong person in violation of due process. And Jennifer's story is a textbook example of how an innocent person in the wrong place, at the wrong time, can be harmed by such a poorly designed system. At Daniel Jones 9937 writes, "The minute they realized she was the wrong person imprisoned and decided not to release her, it became false imprisonment, right?" Well, that's a fantastic question, Daniel. The short answer is maybe. But our theory is that the violation of Jennifer's constitutional rights began well before that, from the moment Deputy Peraza decided to arrest her without verifying her information. The slightly longer answer is that false imprisonment begins when a reasonable officer should have known that they had the wrong person. If Broward County had proper training and procedures in place, they would have discovered their error much sooner than they did. Under the Fourth Amendment, which is one basis for Jennifer's legal claims, courts don't typically look at an officer's subjective state of mind. In other words, what they actually knew or didn't know. Instead, courts focus on what an objectively reasonable officer would have known under the circumstances. But, as you might expect, the fact that these specific officers knew that they had the wrong person is a good indicator that a reasonable officer should have known better. However, the Due Process Clause, which is another basis for Jennifer's legal claims, operates a little differently. Under due process, what the officers knew or didn't know actually matters, because for Jennifer's claim to succeed, she will need to show that the Broward County officers acted with deliberate indifference. This means that they consciously disregarded the risk that they had arrested the wrong person. The fact that those officers eventually knew that Jennifer was not the person described by the warrant, but continued to hold her anyways, is great evidence that they acted with deliberate indifference. Thanks again for watching. Make sure to like, subscribe, and tune in for more videos.